Today we are going to look at economic substantive due process. Chapter 10 deals with substantive due process primarily as it relates to the relationship between businesses and legislatures during the early part of the 20th century and the late part of the 19th century. Due process extends back well over 600 years into English history. It is a protection against government, primarily in the court system. The idea that court must behave in a fair way in order to take away someone's life, liberty, or property. Substantive due process extends this idea to say that governments can't infringe people's life, liberty, or property, even outside of courts. So substantive due process is talking primarily about what is fair, what is a fair action of government, and what government may do in terms of taking away people's rights. Is it life, liberty, property, or maybe even some other concepts? However, what we're typically asking judges to do is to apply a sense of fairness. And this has been criticized as a blanket grant to judges to do whatever they think is right, whatever they think is fair. It says something, right, that our top federal judges are called justices rather than judges. Typically, when we're talking about due process, we're talking about procedural due process. That sense that proper procedures must be followed before we take away somebody's life, liberty, or property, particularly people who are in the court system. However, in the aftermath of the Civil War, states began to regulate businesses, and businesses saw the 14th Amendment as a possible place to improve upon the contract clause. In the slaughterhouse cases, they were actually several cases that were consolidated, all involving butchers in Louisiana. The Supreme Court rejected the idea that the 14th Amendment could be used to protect individuals. They said courts are not super legislatures. But from there, they started to look for ways in which they could give aid to businesses. This did not end the goal of using courts to revisit actions, particularly unpopular actions by state legislatures. Rather, the public supported the courts when they struck down unpopular government actions. However, we're usually talking, when we talk about substantive due process, as a tool of elite opinion, whether the people who had some power were able to create a reasoned argument for why a state legislature did not act in the best interest of the public. In the Supreme Court case Munn versus Illinois in 1876, the Supreme Court struck down a limitation on warehouse fees. Someone who owned a warehouse was saying that the market for their services actually had a price that was higher than what a state legislature had arbitrarily determined should be the cap in prices. The credit or blame for substantive due process can often be ascribed to Justice Samuel Blatchford. He evaluated due process against a range of cases, and he felt that the court had adopted a standard of reasonableness. Reasonableness in the sense of, was the law reasonable in light of all of the circumstances? This is an example of judicial activism. After all, justices were striking down unreasonable laws because they felt that the laws hurt businesses. Justices perceived themselves as protectors against organized interests, or we might say interest groups, and other bad actors, such as socialists. They substituted their sense of reasonableness at the expense of the reasonableness of state legislatures. Justices saw it as their role to put a brake on the reform interests of populist progressives or New Dealers who were trying to inculcate the government with socialistic legislation. Uh, the conservatives on the court strongly believed that the country's best interests lay with an unregulated free market. Justice Peckham, in a case Allgaier versus Louisiana in 1897, said that the rights to contract, or the ability to contract, was a liberty protected by substantive due process. This ties due process and the contract clause together, and it makes a case like Lochner, which we'll mention here in a minute, possible. Lochner versus New York was probably the high point of this economic substantive due process era. In Lochner versus New York, uh, it was a case where the police power of a state, the power of a state to enforce rules against individuals, businesses, or others, is to be tested. And in this case, they asked whether a law is fair, reasonable, and appropriate in its use of state police power. And it found that the right to contract is nearly absolute, and that states didn't have the power to manipulate or change this right to contract. And this led to an entire era that lasted up until the 1930s. So if we were to start with the traditional role of government to pass laws with universal application, nobody's arguing against that. But what about a law that's designed to have a application to a particularized group or a particularized interest? And they suggested that one group couldn't be singled out. Now, we don't need to necessarily go so far as to say that's always wrong, although the court was applying this rule to businesses and the relationship between businesses and individuals in favor of the businesses. We could also ask, well, what about whether individuals are singled out to be less protected by a state legislature? And as we'll see, due process was used in a very different way later. Some people would argue that the high point of the Lochner era was the period between 1923 and 1936. We're talking about a period of economic growth. We often hear people talk about the roaring 20s. And as the US economy boomed and voters elected presidents who were committed to a free market economy, who in turn appointed justices who shared their opinions, we see that this is a period of what some people call laissez-faire economics. A bit of an exaggeration. Warren Harding made the first of four significant appointments that would eventually come to be seen as the Four Horsemen. The Four Horsemen is a reference back to the Bible. If you're one of the four horsemen of the apocalypse, certainly the person who's writing that is not saying anything nice to you. But they're talking about the four horsemen in the sense of being the death of New Deal legislation. The conservative justices viewed the doctrines of dual federalism and substantive due process, along with a restrictive view of the Commerce Clause, as powerful weapons against state and federal regulatory legislation, which, after all, we're seeing was a threat to this free market. And so in the 1920s, they're carrying out the goals of the people who had appointed them. And in the 1930s, they're holding back some of the reforms that Franklin Roosevelt was trying to implement in order to help with the Great Depression. Not to speak to whether Roosevelt's policies were effective or not, they certainly were what the people were asking for at the time. And so this made the court very controversial. Because of the popularity of the New Deal, there was a great deal of pressure on the court, both from the public and probably more importantly from President Roosevelt and Congress to stop holding back, stop striking down New Deal legislation. What we see in a Supreme Court case, West Coast Hotel versus Parrish, the court eventually does relent. Through this case, the court did a major shift on the constitutionality of New Deal programs. And they said that liberty is the absence of arbitrary restraint, not immunity from reasonable regulations. Now, the entire idea that reasonable regulations, again, we're looking at what is reasonable. Well, in this case, reasonable, I suppose, is a regulation that Congress is going to reform the courts if you don't let it pass. Regulation fixes exploitation of workers, which burdens the economy, they said in the case. Well, this is definitely a change from their opinion before they had viewed the regulation as a burden. This case represented the demise, to all intents and purposes, of substantive due process, at least as it related to businesses. After World War II, the court began to adopt a rational basis test for substantive due process. Justice William O. Douglas, in Williamson versus Lee Optical, wrote, "It is for the legislature, not the courts, to balance the advantages and disadvantages of a business regulation." Now, of course, William O. Douglas is probably the most liberal justice, perhaps in the history of the United States Supreme Court. But even Justice William Rehnquist, who could be the most conservative justice since the time of the Lochner Court, wrote that the goal of economic regulation is to protect the consumer, not to protect business. And this definitely gives us a bookend on substantive due process as it relates to the protection of business. Today, substantive due process is largely important for two contexts. First of all, to ban excessive monetary damages by juries. For instance, we could look at the example of somebody tripping over a skateboard and breaking her leg. If somebody trips over a skateboard and breaks her leg, well, obviously there's a lot of pain and suffering that should be accounted for. Maybe a slight punishment for the person who leaves the skateboard out negligently. And obviously medical bills and lost wages and things like that can all be taken into account. But what if the jury says that that's worth $1 billion? Well, our sense of fairness would say that, to make somebody whole would be something less than that. And substantive due process gives judges a chance to revisit this either after the opinion or on appeal. But perhaps more importantly, for our case, is the right to privacy. The right to privacy was justified using substantive due process. Now, I'm not sure where privacy stands. We know a lot about Lochner. Lochner was a decision that's over 100 years old. But the Dobbs decision is much more recent. And so where will we look at this? What will be the effect? Justice Thomas has advocated a general revisiting of substantive due process, but this isn't what the majority did. So, with cases like same-sex marriage, contraception sales, and anti-sodomy laws, all relying at least in part on substantive due process, if that goes away, then I think that, well, that could lead to a large change in the decision making by the courts.